Thank you so much, Bob. It is really a pleasure to be here. My husband is Michael Moore, whom you heard mentioned, and Michael has been so involved with FIBA and the Marine Council over a number of years, and the marine industry in general has been so important, such an important part of his life, personally and professionally, and mine as well. So I am particularly pleased and appreciative of being invited to be here with you today. And this is going to be a change of pace because my area of the law is quite different. Intellectual property covers broadly patent, trademark, copyright, unfair competition, and trade secret law, and not particularly related to the marine industry, but certainly equally related to the marine industry as to other kinds of business. And what I have found over the years of doing this is that there are certain critical points in the life of every business where intellectual property issues become very important or can become very important. And if you're going to have problems, these are the times that they're going to arise. So I'm highlighting 10 of them for you. I'm not going to keep you in suspense. The 10 of them are, first of all, anytime you're selecting a new name, if you're forming a new company, forming a new business, a new trademark, a company name, if you're offering a new product or a new service, if you're coming up with a new slogan and a new marketing campaign, you want to be very attuned, particularly to trademark issues, to be certain you are developing a name and a brand that you can protect, that can be yours and that you can protect it against copycats. And the other thing you want to be careful about is that you're not infringing somebody else, because the doomsday scenario is to launch a new business or launch a new product with a trademark infringement lawsuit. So we're going to talk a little bit about that. Another time when intellectual property issues become critical is in the event of a sale, a merger, an acquisition of a company. Also, when you're introducing a new product or a new service, very, very similar to what we talked about earlier with a new company name or slogan. If there's a new invention, when you're bringing in a new employee, that can give rise again, both, what is this employee bringing into the business or the company? Is there something this new employee is doing that might get your business or your company into trouble? And that's equally true of independent contractors. And there are some particular issues that we're going to talk about with respect to independent contractors. A new advertising campaign, there are trademark issues, potentially copyright issues, and you also want to be very careful that you're getting the right clearances and permissions. Anytime on that issue, on the issue of clearances and permissions, anytime you're using the name or likeness of an individual, you just need to be alert to the fact that there are particular considerations in that regard. When you're creating or changing your website, and when you're getting involved in international business. So let's look first at a new company name, and by housemark, I really mean trademark, your primary trademark, and a slogan. A slogan can be a trademark as well. The greatest show on earth is a registered trademark, for example, and a lot of us use slogans or taglines in our businesses. So what you want to be careful about is that when you have a trademark, you protect it appropriately in every significant market, every market that's significant to your company. And by that I mean basically every country. We're talking specifically about the registration of trademarks in the United States Patent and Trademark Office. Basically, you register country by country by country in other areas that are important to you. And there are legal benefits. You're not required to register your trademark, but there are significant legal benefits to registration. One of the ways I always explain it is you own your car, but unless you have a certificate of title, nobody's going to buy the car from you. This proves your ownership, basically. But it is actually more than that. There are a number of statutory benefits that go along with registration that can be very important in defending your mark against third parties or enforcing your mark against third parties. And the other thing is just simply the fact of registration makes your trademark ownership a matter of public record. So you'll never know how many people are deterred from potentially infringing your trademark by the simple fact that you have a registration. In addition to the legal advantages, there are significant business advantages to obtaining a trademark registration. Number one, a trademark is an asset of your business. And if you've got that certificate of registration, you have proof that it's an asset of your business. So if you're bringing in partners, if you're looking for investors or bank loans, anything of that nature, it goes right to the bottom line of the value of your company. And the value of the trademark, the minute you get a registration, is worth multiples of what it cost you to get the registration. It's also potentially an income-producing asset, because you can license your trademark, permit others to use it upon payment of royalty or with or without royalty, but it's, as I say, potentially an income-producing asset. And there are some favorable tax advantages you can get with trademark ownership. But the two points, key points I want to leave you with, first of all, as I mentioned briefly, be very, very careful that you are selecting a mark that is not going to infringe someone else. So how do you do this? You search a trademark to be sure that you're not using the same, obviously, mark as somebody else. But there's a lot of misconception about how close is too close and what is considered infringing. So the legal standard is, if the average guy in the street, if the average person is likely to be confused by your trademark, given the existence of an earlier mark, then you've got infringement. And I can't tell you how many times clients have come in and say, oh, well, I'm spelling it differently, or I'm using a singular rather than a plural. That is not good enough. A trademark is infringing if it looks similar, not the same, similar, sounds similar, or has a similar connotation. And that's because trademark law is very, very logical. You and I are consumers. If somebody recommends a restaurant to us, we're not going to remember how it's spelled. We're not going to remember whether it's singular or plural. There are a couple of key things you're going to have in your brain, and when you see something that looks similar, you're going to go, aha, that's the one my friend recommended. And that's the way it works in real life, and that's what the law recognizes. And I'll give you a good example of this that's almost a little counterintuitive, but there was actually a skating rink in Atlanta a number of years ago called Jelly Beans. And a competitor opened a skating rink called Lollipops. And the court actually concluded, there was a trademark infringement suit, and the court actually concluded that that was trademark infringement because conceptually they were similar. And there was evidence before the court that, moms or dads taking their children to a skating rink would see Lollipops and say, well, isn't that cute? They opened a second location. It's a children's candy name. It sounded like it might possibly be the same company. So don't fall into the trap of thinking, well, it's not exactly the same, so I'm not infringing. The question is not, is it the same or not? The question is the average person with our imperfect recollection gonna possibly be confused that there's an affiliation or connection, or so be careful. The other thing you want to be careful about is that you can be your unique branding. The marine industry is not an exception in this case. Every business wants to come up with a name or a brand that will just immediately convey to their potential customers what they're doing. PC Solutions, good used cars. That's great. That immediately conveys to the public what you're doing, but it's not protectable as a trademark. Anybody who sells good used cars can use the terminology good used cars. So you want to try to be unique, distinctive, and the key to remember is not descriptive. You come up with a name or a brand that conveys the marketing messages you want to convey without directly describing what you're doing. So like so many things, that's simple but not easy. But I'll give you an example. One of the greatest trademarks ever developed was Apple. Because when Apple was coming up with their brand, what they were dealing with in the computer world at that point, the names, you remember, were were very technical sounding, kind of IBM, you know, they weren't user friendly, and there was a lot of resistance of the public to technology and computers. So they wanted to overcome that resistance to the public. They wanted to make it sound basic, wholesome, mom and apple pie, you know, easy, easy, easy. So what's more simple and wholesome than an apple? Also, their whole marketing campaign was to go into the schools. So an apple for the teacher, an apple a day, you know, it was a very simple, basic, non-threatening trademark that conveyed a lot of marketing images that they wanted to convey without having anything at all to do with computers. So, like I said, it's simple to say it, but not at all easy to do it, but that's the ideal. The next juncture we're going to talk about is when you get a merger, a sale, an acquisition, some sort of a company transaction like that, really critical to take into account intellectual property issues and see what's there. If you are selling a business, you want to know what you're selling. Are there registrations? Are there patents? Are there license agreements? Every business these days has computer programs. Those come with licensing agreements. There are a lot of things that you are actually conveying in connection with the sale that add to the value of what you're selling. So you'll want to know about that to get top value in terms of your sale. On the other hand, if you're the buyer, you want to be certain that you're acquiring everything you're paying for, that you're acquiring what you're entitled to. And again, I'll give you a quick example. This happened to be a boating manufacturer, a boating company, sold the assets of the business and failed to take into account, neither the buyer nor the seller took into account that there were registered trademarks involved. We actually contacted the client and said, you've got these trademarks, you're due for renewal, do you want us to renew your trademarks? And he said, oh, don't bother, I sold the business, I sold the company. And we said, well, your trademarks are still in your name. You know, you need to convey them to your purchaser. And in doing that, we found out that there was actually a cloud on the title. There was a lender from years earlier had filed a lien against the trademarks, had recorded the lien in the United States Patent and Trademark Office. So not only did the trademark registration remain in an incorrect name, there was a lien, the loan had long since been repaid, but the lender didn't file a release of lien. So we had to go back in and clean up the release of lien and get the mark conveyed. But again, it's just something you want to be aware of. And there are other things as well. There may be copyright registrations, patents, agreements. Just be sure that you get a complete sort of due diligence on what you're buying or what you're selling. When you come out with a new product or a new service, you've got all the issues that we talked about with regard to trademarks, with selecting the right mark, being sure you're not infringing, getting registrations as necessary. But there are other things as well. Chances are you're going to have copyright issues. You're going to have new text, new explanations, new advertising materials, new postings on your website. So those largely are going to be copyright issues. Copyright covers photographs, graphics, drawings, textual material, pretty much everything that's on a website or in an advertising brochure. And with copyright, you want to be careful of a couple of things. First of all, there's still sort of a lingering misconception among some people that you can download things from the internet and internet is public domain. Absolutely not. Anything you see in the way of graphics, designs, photographs, video clips, music, film clips, anything like that, assumes someone owns it. And you have to be so careful, especially these days, because there are computer programs that will go out and search and find infringing content, and we're seeing a lot of litigation now over photographs that have been republished or video clips, audio clips, things like that from the internet. And again, it's sort of, on the one hand, you sort of know it, that this belongs to somebody and you've got to get clearances. On the other hand, it's so ubiquitous. You see YouTube postings, you go on Facebook, and people cut and paste pictures and share pictures. So on the one hand, you realize there's a potential problem, but you see it so often that you sort of develop an immunity to it, but count on it. If you are, and unfortunately, the more successful you are, the more likely you are to be a target, the more successful your campaign is. So just be mindful of that and be sure you're getting releases, clearances, whatever you need to get to use content from someone else. Potentially, a new product could involve patent. So let me talk just a little bit about patents. Really, the most important thing for you to know, patents are potentially available for new developments, inventions, improvements on existing products. But the most important thing for you to know about patents is, in the United States, at least, there is a 1-year time bar from the time that your patent is first made known publicly. So if you publish an article about it or publish an advertisement, if you put it on sale, if you use it in public, you've got 1 year to get a patent application on file. And on the one hand, that sort of sounds like plenty of time. On the other hand, it really isn't, because you go through the process of finding a patent attorney, getting a search conducted to be sure that the invention is actually patentable, writing up the patent application. These things take time. In other countries, you don't even have that 1-year grace period. So if you remember nothing else, be sure to remember that 1-year time bar. So if there's something that is potentially patentable, don't wait. Look in. We have the situation all the time where a client will come in and say, got this great thing, nobody else knows about it, we created it in our business, we've been using it for the last 3 years, and we really, really want to protect it. And it's heartbreaking, because then it's too late. The other thing, and this probably has broader application because this applies to every business, and that's trade secret protection. Virtually every single business has trade secrets. And trade secrets, very simply, it's broadly defined. It's any information that you personally or your company, your business, has developed over time with the expenditure of time and effort that is not generally known to the industry at large and is advantageous to you in your business. So the classic, the greatest example of this is in yacht brokerage, your contact list, because that's sort of the lifeblood of the brokerage business. It's not just names and addresses and contact information, but it's a full database of, who bought what boat when and what their preferences are and their family and, that sort of thing. So there's a lot of, just a wealth of information there that you individually develop. Certainly not generally known. Everybody's, developed it over time through their own contacts. And this is, by definition, by Florida law definition, this is a trade secret. And it is protectable if you have taken measures that are appropriate under the circumstances to protect your trade secrets. So what would that be? Databases are password protected. Databases are available on a need-to-know basis. You do not have to turn your business into Fort Knox. Obviously, if you have perfect protection, you have limited the usefulness, the utility of the information to you. That's why the law says reasonable under the circumstances. But as long as you're taking reasonable measures. The other thing is agreements with your employees. Agreements and what's yours, what's mine, what do you keep, what do you take with you, that sort of thing. This is just a copy of the Florida Uniform Trade Secrets Act, which we talked about, and trade secrets get to be particularly important when you're bringing in a new employee. And I'll give you a perfect example. There was a gentleman who was in the marine industry for years, had developed his database, his list of contacts and information, was hired by a new company. This was a build company, manufacturing company, and had that information with him on his computer, was hired to be the president, used his computer in running the company in conjunction with the company business, and ultimately left the company, but now all of the company information is on the computer as well. So that gave rise to a conflict over what information was yours, what information is ours, what do you leave with us, what do you take with you, and it really would have been relatively simple to troubleshoot that in advance if the guy had been given a new computer. Here's the computer you use in connection with this business, and this is what you do. And the most important thing there is just to understand what are your trade secrets? What is it that you know in your business that you wouldn't want your customer, your competitors to know? And then figure out what are your policies, what do you need to do about that, and just be sure that those policies are understood and agreed at the outset. Again, simple to say, not that simple to do, but at least you know what the objective is. So employee agreements, and then at the conclusion of your working relationship, exit interviews. Talk to the employees as they leave you and be sure that the understanding is clear, you're all on the same page, and you can avoid a great deal of trouble. Independent contractors bring with them some particular issues. Basically, the general idea is the same, but when an independent contractor creates work, creates information, photographers, when you hire a photographer to take a picture of a yacht, when you hire a programmer to create a website for you, you are retaining an independent contractor. And the key thing to remember with independent contractors is when they create something copyrightable, they own copyright. And a lot of people are familiar with the idea of work for hire or work for hire agreement. And the problem there is just because you say something's a work for hire, it's not. You can't rely on that. The copyright statute is very, very specific about what a work for hire is, and it's not what you think it is. If you are a full-time employee, employed for the purpose of taking the photographs or writing the software, fine, that's a work for hire, and your employer owns the work. But if you go out and just hire somebody, a freelancer, to come in and take these photographs, it's not a work for hire unless you fall into a very, very narrow range of statutory definition, and very few situations do. So I recommend you get an assignment of copyright. I would add to that a covenant not to sue, release an assignment, put in as many belts and suspenders as you need to, but just, again, this is to alert you to be mindful if you go. And the thing that sort of drives me crazy about this is it's counterintuitive. You go out and pay somebody to build a house for you, you own the house, So we're accustomed to thinking in those terms, and it doesn't work that way with copyright and copyrightable subject matter. Advertising, when you're coming up with new advertising campaigns, any sort of advertising and promotional concerns, basically you're looking at the same kinds of things, the same trademark issues that we already talked about. You're looking at, art, photographs. These can be registered many times. Copyright registration, you can get assignment of copyright if you need to. With comparative advertising, we're better than the other guys because of this. You can do that, but you'd better be very, very careful that what you say is objectively truthful, subjectively truthful. It doesn't imply something that's not truthful, and that you can back it up. Let me go back a minute. One quick story about advertising We had a client one time, years ago, who went to an advertising agency to create a whole new branding campaign, package design, advertising, slogans, the whole experience. It was based around an absolutely gorgeous photograph of a tiger that this advertising agency had found on the internet. And you know where this is going. The photograph of the tiger was, of course, copyright. It was a copyright violation to use this, and it wasn't the advertising agency's liability, it was the business's liability for having infringed copyright. So again, new advertising campaign, promotional materials, just be alert to that. I mentioned briefly using the name or the likeness of an individual, get a release. And this comes up, you'd think, oh, how obvious, naturally you have to get a release. But I'll give you a good example. We had a client who came in, formerly worked for a company. On his company's, he was no longer there, he had left the company. On his company's website were a series of photographs of the physical plant of the business and various employees of the company interacting with other people, and he was still on the company's website. And that would have been a direct violation of Florida law that says anytime you use the name or likeness of an individual for a commercial purpose, you must have a release from that individual, or they have a cause of action against you. And you can see how that's the sort of thing that could come back and bite any business. How many businesses have shots of business events, social events, brokers interacting with people at boat shows. So again, it's something to be mindful of. Anytime you create a website or change a website, same thing. Be careful about trademarks, be careful about content, and most of all, be mindful of the fact that if you have gone to an outside programmer to create a website for you, they own copyright in your own website. So be careful, look to your agreements. What are the agreements you have with them? Ideally, you want to have access to the source code, you want to have ownership of copyright, you want to have access to the source code, so that if you need to go to somebody else to come in and revise or to alter the website, you have the right to do that. That's easier said than done, because if you're a big company and it's a big transaction, you obviously have a lot more bargaining room and leverage, but software is copyrightable subject matter, and websites are based on software. The other thing is clear your domain name. Be careful, because a lot of people, we've seen it a number of times, companies will use the trademark of a competitor as a domain name that just simply redirects to them, or companies will use a misspelling of a competitor's name to redirect to their own websites. So if you see something like that, that's a violation of rights. And you know that it's probably goes without saying, but with domain names now, it's so inexpensive to obtain and maintain a domain name. You might want to just register yourself a number of different variations on your own company name or trademarks or business name to resolve to your website. And then there has also been trademark infringement found when trademarks are used as meta tags, hyperlinks, wallpaper, different things like that. So even though it's not necessarily visible to the consumer, using a competitor's trademarks electronically can result in infringement. And now finally, just a word about when you're doing business internationally, when you are speaking with a potential foreign business partner, be very careful. One of the things that happens in the United States, the first person to use a trademark is the owner of the trademark. In most of the rest of the world, the first person to register a trademark owns the trademark. So when you start talking with a potential non-U.S. business partner. And again, real life example, we had a client who was talking with some people in Japan about a potential business relationship, and the Japanese partners ran right out and registered my client's trademark in Japan in their own name, ostensibly to protect their future business partner. But as a factual matter, what it really did was it tied our client into having to do business with these particular guys. They now own the name in that country, and in the event the negotiations had fallen apart, had not gone through, our client could have been prevented from going into the, happily that situation resolved itself favorably. But that kind of brings us back around to the very first point, which is think seriously about registering, about protecting your trademark, your brand name in every geographic market that is of significance to your company. So, one final thing, The other thing is you want to be very careful that your trademark, your branding, your slogans are appropriate for international use. Don't think small. You're working worldwide. And a couple of examples of trademarks that really did not translate well into other countries. Chevrolet Nova, which most of you probably know, Nova, won't go in Latin America in Spanish, Nova, which is really not the marketing message that was intended. And you also know, I'm sure you're familiar with Southern Comfort, the alcoholic beverage Southern Comfort. A number of years ago, a competitor came out with a competing, and this is a little distasteful, but it turns out they tried to market it in Germany, and it turns out that in Germany, mist is slang term for excrement. So again, not exactly the marketing message that you want to convey. So just be mindful of translations as well. So thank you very much. With that, I'll conclude. Good. Yes, indeed. The question is, what is the difference between a trademark and a brand? And as a trademark lawyer, I think, well, they're the same thing, but that's not actually true. Brand is actually a marketing term. It's not a legal term. So if you're talking to the marketing department or a PR company, they're talking about brand as branding, not just the trademark, but the trade dress, the colors, the packaging, the slogans, the entire ad campaign, positioning that brand. So brand is a marketing term, not a legal term. The trademark is kind of the key part of the brand, but there is definitely overlap in the two terms.
I have a question about cease and desist. It's a personal experience. I had this company called Bob Saxon Associates for many, many years before I sold it to Camper Nicholson's, and I had a call one day. This is on cease and desist, okay? And I had a call one day from some guy named McCormick who said he was chief counsel for the Boy Scouts of America. And I didn't catch it right away, but he said that I was infringing on their heralded and universally acclaimed and lauded trademark of BSA, and that I should cease and desist of the use of BSA. And when you get a cease and desist like that, then I'll tell you the outcome in just a second. But what happens then?
Well, what happens is, first of all, you have to consider, is this a valid complaint? Is it a valid question? If it actually is somebody who's in your sort of realm of business, and they were there first. The first thing you look at is who was there first, but probably not much question about that in this case. But that's the first thing you look at. Who was there first? Because first in time, first in right, number one. And then number two, how close are they? There are factors that the courts look at. How similar are the businesses? How similar are your potential customers? How similar are your marketing channels, your advertising? Are people really going to be confused? And in many cases, you can make a very good case, and what we always try to do is talk them out of it in this case and go through the factors and say, and it works in many cases. There's Delta Airlines and Delta Faucets. Who's confused? There's, Jaguar cars and the Jacksonville Jaguars. And I'll never forget hearing a sportscaster at the time, because Jaguar cars originally objected to the Jacksonville Jaguars, and the sportscaster came on the air and said, "Oh, I'm so confused. I'm so confused. Do I buy a T-shirt or a car? A T-shirt or a car?" You know, so you've got to be realistic about this. Is this really going to cause confusion? And in this case, what you're doing is very, very different from what the Boy Scouts are doing.
But this guy was good because my first reaction was to do my best impression of Ralph Cramden, ha 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 ha. And then he said, "Hey, listen," I said, "Well, what can I do to satisfy you?" He said, "Well, you're in the big yacht business, right?" And I said, "Yeah." And he said, "Well, we have this big camporee in Fort Lauderdale every year over at Holiday Park. And what's the chances of me and a few of the other den leaders," and of course I told him I was a Cub Scout at one time, but some of the Eagle Scouts getting on a big yacht and taking a ride down the Intercoastal. And I said, "Done, over and done." And I did get a release from him on that basis. So.
Perfect example of the win-win.
We have one question from the audience. Daphne.
So this is sort of more relevant to what I think most of us experience a lot of. And I think there's not a lot of clarity from our standpoint on photography used on the internet with yachts. So many of us know that there are photographers that ask for their copyright to be on those photos. It's less about those photographers, in my personal experience, than it is about other companies then using those photos over and over and over for their marketing purposes, even if they didn't get permission. Is that something that's different, like US-based versus internationally, and how's the internet interpreted in that way?
Okay, I'm not sure I totally understand the question. Right, you're talking about international as opposed to U.S. rights to photography?
Right,
but I think your first point is very, very valid, that in many cases a photographer, and we've had this happen, a photographer will say, "Look, I don't mind if they use my photographs, but I want credit. I want a byline because it's promotion for me," which is great. It's kind of like Bob's example of a win-win. You know, you can resolve a legal issue along mutually beneficial business lines. But the broader question, I think, is, are they treated basically the same way internationally as locally? And yes, for the most part, there's a universal copyright convention, and over the years, U.S. copyright law has been changed a number of times to bring it more and more and more closely into line with international copyright law. So for the most part, it's going to be pretty similar globally.
So if it's not actually copyrighted, though, if that photo didn't have the copyright, then it's free to use, would you say?
Excellent question, because exactly what I'm talking about. For many, many years, and most of us came along in the time when we had notice. If something had a C in a circle, all rights reserved, or the year of the that's what was required under U.S. law historically for something to be copyrighted. And if it didn't have that copyright notice, it was public domain, we could use it. One of the changes in copyright in U.S. law that has come about in the last number of years to bring us into conformity globally is there's no longer a need to have that copyright notice. So now, if you see a photograph by way of example, a photograph on the internet, you have to assume that somebody somewhere owns the rights to it. So that's a really, really good question, because that's a change in the law that took a lot of people unaware. Thanks so much.